Mr. Clement, can I just bear down a little bit on your test because I'm still trying to understand it with respect to intent. You say that the intent aspect of this is established by knowledge that a customer, specific knowledge that a customer is substantially certain to infringe. And I guess where I want to go with that in asking you is, once that is established, is that an inference of intent? Is there something that the defendant could do in response to establish, to rebut that inference? Or are you saying that all that is necessary is for the plaintiff to show that, and then the intent, to the extent it's an element, is satisfied, and that's it?
What I would say is I think that's enough on the intent element to get to the jury. It's not enough to get directed verdict in my favor, but it's enough to get to the jury. And Cox can go and they can try to argue that, oh, no, we had the purest intent, we tried really, really hard.
Could they point to all the things that they did that they say was enough for the safe harbor, even though the other court found it wasn't? Could they point to those sorts of things as evidence to rebut this suggestion that they intended for this to happen?
Yes, but of course I could point to the DMCA email,
yes,
and I think I'd probably do all right on that exchange.
Sure.
And keep in mind, this went to a jury, and it went to a jury of 12 people who probably didn't want to lose their internet connection. And yet, hearing all the evidence here, they had very little trouble saying this is a case where there is material contribution. This is a case where there should be aiding and abetting liability because of the conduct that took place here. And I guess I would just sort of take a step back from this to say, if you think about this kind of in Halberstam or Twitter terms, there's two kind of elements that are critical. One is the intent element. And if you look at Twitter and you look at Halberstam, the intent level is not purposeful. And then the other question, of course, is material contribution, or in aiding and abetting terms, substantial assistance. And I think the one way in which the copyright laws, the trademark laws are a little bit different is I think they do think that when you are providing the means of infringement to somebody, that's pretty easy to show that that is material contribution, substantial assistance. And so if you're looking to distinguish the FedExes of the world, the electrical companies of the world, agree with Mr. Stewart. I thought he did an excellent job of sort of parroting what my answer would have been with respect to the DMCA. But I would also say, there's a difference when you're providing the means of infringement, which is what the ISPs do in these cases. That is going to be material contribution if you're doing it with knowledge of specific customers and what they're likely to do. And that's true in the trademark context as well, where you're providing it. The Inwood case is you had a drug manufacturer who's giving it to somebody, and they know that person, that generic person, is passing them off as branded pharmaceuticals. And that's where this court said, yeah, there's liability for that.
So there was